Welcome to today's podcast. I'm Mike McCarthy, the broker and owner of Metro DMV Realty, based right here in Reston, Virginia. I've been in real estate for over 2 decades and launched my independent brokerage in 2020, serving clients throughout the DC metro area. I'm honored to have a special guest with me today, someone I've known for over 33 years, which is hard to believe. He's a former public safety legend, a trusted estate planning expert in Annapolis, Maryland, and a personal friend, attorney Jason Johnson of Johnson Law. Wow, Jason, thanks for coming in. It's really good to have you in here today.
Thanks for having me, Mike. I'm thrilled to be here today, and I think public safety legend might be a little bit of an oversell, but I'll take it.
Okay. Well, hey, thanks again for all your service. And if you could, can you tell everyone, just give everyone a little bit of an insight on what you're doing today, and obviously estate planning. Let's go ahead and hear what you're up to these days.
I'll be happy to do that, but first, before I do that, I do want to tell one quick story that you may or may not even remember from somewhere close to 33 years ago. There was I was actually working as a career paramedic in Prince George's County, Maryland, and you and I both lived in the Baltimore area, and there was a torrential snow downpour, and I had to go work a 24-hour shift on a Sunday. It's probably like 1996, so just about 30 years ago. And I called all the people I knew with pickup trucks until I called you, and everyone had somewhere else to be that could. I needed to get to work. Is the bottom line. It was like a blizzard out, and I called you, and I knew you were a good friend because you dropped everything you were doing. You came and picked me up, and I felt really guilty when we were about halfway down to where I needed to be to work, and you obviously had major regret that you were driving me through this torrential downpour of snow. But I always remembered that, and I always appreciate it. It just speaks to who you are as a person. So I really am still grateful for that. So I am, as you said, I worked a full police career in law enforcement. I worked in the fire service and then in law enforcement, and the fire service is where you and I met. Eventually, I went to law school many years ago, and I decided that I wanted to be an estate planning attorney. So I started my own practice. I worked for another attorney for a little while, and then I started my own practice, and we're based in Annapolis, Maryland. And our practice really is focused on estate planning issues. We do some what we call elder law, and elder law, as I try to describe to people, it's kind of a good way to think about it is it's kind of like estate planning for people in their retirement years. And people in their retirement years have unique needs, concerns, challenges, and the like, and elder law attorneys are there to address those. Everything from planning for incapacity, obviously estate planning, and planning for potential need for long-term care, and that's sort of what we do. Many of my clients are in retirement years, and many are not, and we love to serve small business owners, families, anyone that is concerned about the issues that estate planning and elder law attorneys address, which we will, I'm sure, talk in great detail about today.
For sure. Estate planning is obviously something that none of us like to talk about, right? My wife and I were literally just talking the other day and thinking, wow, we're almost, I'm almost 50, right? So she's a few years older than I am. And, at that point in time, you do have some assets, maybe some things have changed a little, but I know that's not just unique to somebody in our age, category. I know it's important. I know that, clearly there's so much involved with, on my local brokerage side, we deal with some estate sales and so forth, and where it's, obviously already the deceased has already passed, right? And the heirs are now trying to, sell the property and close out, probate, which we'll get into here in a minute. But, it's definitely something. Life is, we're all going to have to look at some point down the road. It's going to happen to all of us. So we to have our affairs in order. I'm sure you can share some experiences of maybe somebody whose affairs weren't that in order that has come to you for professional advice. But I guess to start out with the real basic fundamental question, just explain what is estate planning, if you could.
Yeah, great question. And a lot of people ask that, by the way. So it's normal to be curious about that. But the tools that we use as estate planners are kind of what we're known by. So things like wills and trusts and powers of attorney and other legal arrangements that are designed to do a lot of different things depending on what sort of needs to be done. On the most basic level, people's main concerns when they come into our office, the thing they're generally thinking about is, how can I set up a plan so that I know and can be confident that whatever I've built up, whether it's real estate or for some people it's an investment portfolio or a business, how can I know that if I become incapacitated, and incapacity, many people think of estate planning as, well, that's just for when I pass away. Really, it's not. Becoming incapacitated is a growing, as we live longer, more of us will spend some time in our lifetime incapacitated, unable to manage our own property, unable to manage our own healthcare decisions. Estate planners deal with those concerns of what happens if you become incapacitated and what happens when you pass away. Who is going to manage your decisions if you're unable to make them, and where is your property going to go? People are worried about things like taxes. People are worried about things like continuing a small business in the family. People are worried about real estate. I've got a property, my home I'm not worried about, but I have this cabin that's been in my family for 3 generations, and I want it to stay in my family. How can I make sure that that's going to happen and that it's going to be properly managed after my lifetime? All of those issues and more are things that estate planners are concerned themselves with.
Yeah, it's quite a bit. I mean, if you're not planning, I don't see how, in today's world that we're in, how you couldn't think about those things. I mean, we think about, our retirement plans, we think about, our savings accounts and all those other things. And a lot of times, you even hear today, well, is Social Security going to be around anymore? You know what I mean? So it's those things that, I think sometimes are taken for granted until we hear situations where, well, if Joe or Sally would have just planned properly, they may not have had these issues right now. But, probate's a very, it can be a complicated process. And, I'd like for you to, if you could, educate the audience on, our viewers, what it is and how can it be avoided, actually?
Yeah. So I practice in Maryland, so most of my experience, if not all of my legal experience dealing in the probate process is in Maryland. It is a state-specific process. So every state in the union has its own state laws and practices and procedures of its courts. So it's going to vary slightly depending on the state. But the one thread that kind of runs through the probate process is the probate is the legal process of sort of unwinding a person's property after they have died, making sure that if there are any creditors that have lent them money before they passed, that they're going to be made whole, and that eventually there's going to be a person appointed to be the manager of the estate. And different states call it different things. Some states it's called an executor, some states it's called a personal representative, and there probably are some other terms that are used in other states. That person has to be appointed by a court. And I think when we start talking about what actually happens, especially with real estate in the probate process, one of the key things to understand is that only a person who has been legally appointed by a court or in some cases there's some administrative agency that would appoint them, has the legal authority to sell property or to deal with property of an estate. But the probate process is set up to, in an orderly way, appoint a person who is in charge, make sure that any creditors who may have, creditors of the decedent have been notified in some way that the person has passed and have an opportunity to make claims against the estate so that they could be paid back from estate property. And then the ultimate goal is to, at the end of the process, whoever are the beneficiaries, and those could be people who are named as beneficiaries in a will, or if there is no will, they could be people that are identified in state law as being people that would receive property of the deceased person. A typical probate process takes about a year in many states, some states significantly longer. In some states, I think there are summary processes that can shorten it up a bit. My experience is in Maryland, and I can tell you that a year is very typical. If there are any complications, it certainly could extend beyond a year. When I say complications, I mean if there are tax returns that need to be filed, if anyone files what's called a will caveat, challenging the validity of the will, that would certainly extend it well beyond a year. So very familiar with probates that take many years to close. A typical simple one, we're looking at about a year.
Interesting. I can tell you, outside of the probate process and talking about, well, who has the legal authority to sell this real estate now, we run into a lot of times on the brokerage side of things. I'll tell my agents even, like, look, you can't take Joe Smith's word that this is his vacant land, right? So we deal with a lot of this. Hey, I have a vacant lot to sell. You know what I mean? And there's no way to validate who is this legal owner. They say that they're Joe Smith, but really are they? So what we require is those documents from the courts to verify clearly that this person has the legal authority to sell, the deceased property. So
we got a call, Mike, from a potential client just a couple weeks ago who was had a relative who passed and who owned a home and not much else. So really they were focused on the home, and they were very anxious to get it listed with an agent. So they were like, can I do it today? No, there's a process where we have to get you actually legally appointed to have the authority to do that. So you have to follow a very stepwise approach. And I think any responsible realtor or broker would very upfront require evidence that a court has authorized you to act on behalf of the estate.
Absolutely, absolutely, very good. You know, I do want to ask, you know, we everybody's looking to save a buck today, right? So, you know, you at times, you know, I know we run into it on my side of the business at times, but, you know, do you let's just talk about some, you know, common estate planning pitfalls. And one of the things that the questions that I had for you is it pretty, would you say, I wouldn't say commonplace, but do you ever hear about people saying, hey, I'm just going to do it online, I'm going to do this will online? I mean, save me some money and just, you know.
Sure. Well, it definitely will save money up front. There's no doubt about it. It's similar to trying to list your property by yourself and sell a property by yourself. I think people maybe feel like it looks really easy and they can just go do it. I think there are two primary mistakes in estate planning. One is not doing anything. That's a big mistake. And then the second, and as big of a mistake, is to try to rely on an online form producing service. And the only thing I would say is that I personally, as an estates and trust lawyer, I get people that come into the office. Usually it's after a relative has passed away, and they come in and they say, hey, this is the will, and you can look at it, you can tell it was produced online. And very frequently there are big gaps. Maybe it's not executed properly, just simply wasn't done right, and won't be considered a valid will under the law, and under the laws of Maryland, and maybe in other states as well. But even more often, it's not how it was signed or whether there are enough witnesses or what have you. It really is just big gaps in the logic that any professional who is an estate planning attorney would guide you through and would counsel you not to do. And they turn out to be big mistakes. You could be missing what's called a residuary clause in a will, which is a very big problem if your will does not have a residuary clause. Sometimes the way that people make plans for how their property should be distributed, they do it in a way that seems intuitively right, but any professional estate planning attorney would say don't do it that way. So for example, I've seen wills come in that were, again, there was no advice received from an attorney, where there is a spouse, two spouses, one of them has passed, and there are children, adult children, minor children, doesn't make any difference, where the will divides the estate between the children and the spouse. And I'm not saying that's never a good idea, because there certainly could be an application for that. But for most people, most middle-class people that have an average-sized estate, the surviving spouse needs to have enough money to make it through the rest of their life. And that's something that sometimes people don't quite think about. They think, well, that seems fair. If I pass away, I certainly want my kids to get some of what I have. And they're not thinking, well, but how about my spouse? Are they going to have enough money to make it for the rest of their life? And depending on ages and health and concerns about long-term care and many, many other considerations that an actual professional would be able to counsel a client on, they skip through that and they just click the box without thinking about it. And so you wind up with a bit of a mess or an undesirable result. And we see that very, very frequently. We have people that come in often when they've reached a particular part in life where, you mentioned earlier about how estate planning, kind of the older you get, the more you think about it, I guess. And I've noticed the differences in how younger folks think about estate planning, how sort of middle-aged people, kind of like our age-ish. And then there's another kind of stop, and that's retirement years. There are many different goals along the way. And that people will come in when they reach one of those milestones, and they will have that old will or old trust that they did online, and you look at it and you're right there and you're like, you got major problems here. And like 100% of the time they're so happy they came in, because they're like, I would have never known, I just assumed everything was okay. But the real big difference is not so much the forms. Normally the forms, they're okay, they probably just aren't doing the right things that they should be doing, and any professional you would deal with would probably convince you to do it other ways. And
is it easy enough for you to remedy that? Like when somebody comes to you with one of those botched up wills?
That's a good thing about estate planning is, with some exceptions, as long as the person is still living and they still have the legal capacity to make a new plan, with very few exceptions, we can fix everything. So when I say few exceptions, I mean sometimes you get somebody who's locked assets up in a way that is difficult to undo. Certain types of irrevocable trusts and other things would be difficult to undo, but very seldom would someone do something like an irrevocable trust online. Most often that's going to be done with professional advice and actually an estate planning attorney preparing the documents. But I would say generally speaking, we can fix the problems when they present themselves.
That's good to hear. That's good to hear. That actually is, going into like real estate and probate and the role of professionals and what they play in the process. Clearly, I know in my industry, very low barrier of entry, right? So there's a lot of people that all they care about is getting this house sold and, not really understanding the process. And, well, how long is this going to take? And it's like, how long, are you patient? We got to get through the process, and it is the process. So, having said that, you probably have, I don't know, do you ever have to referee this with a title company or anyone calling you as the estate, attorney on record? What is your involvement in that regard? Are you typically kind of hands off at that point once the executor has hired their own, agent to deal with this? Are you ever involved at that point?
Yeah, we stay involved. Obviously, we're focusing on different issues than the realtor is. So our role as the estate attorney is sometimes they don't have a realtor, they don't know a realtor that they should deal with. Sometimes we have executors or trustees that don't even live in this part of the country. They don't have any network here. So we can help connect them with people that we know and trust. Yeah. That's number one. And then the valuation is a consideration sometimes. So the price at which the home will be sold is sometimes a concern. If you have multiple beneficiaries, you want to make sure that the home is being sold for what is truly fair market value, because the executor has a responsibility to do that.
Well, that brings up another question I had for you then. So, you talk about fair market value and evaluating an estate. Is that an appraiser's job, or is that really a broker's job? We have, as brokers, we're not licensed appraisers, so we don't do appraisals, but we do market analysis, and then for the banks on our REO portfolio, we do what's called broker price opinion, so we can get a pretty good understanding of, and we can have a pretty good conversation with that executor and what the property's worth. In terms of the courts, though, where does that stand? Do they just come to you and say, hey, what do you think it's worth? Do you actually...
So generally speaking, you don't have to get, at least in Maryland, in most situations, you don't have to get advanced approval from a court to sell a property. It's the executor, or in Maryland we call it a personal representative. It's their responsibility, and they have the authority to sell the property. In terms of the valuation, an appraisal is usually warranted to get an appraisal, at least to get a baseline idea. What is this property likely worth? But you probably know as well as I do, an appraisal is an expert opinion on what it's worth. Exactly. When you actually take it to market, you may find out otherwise, right? So there's also risk considerations for any seller, obviously, but especially for executors who most likely aren't that familiar with the home, have never lived in the home themselves. They don't know what all the little things that might have a problem with an inspection. So if it's going to be a transaction that's going to require an inspection from the buyer, a professional home inspector, if there is some cause for concern if you're an executor, like, well, how's it going to do? Right. If we want to have a transaction that you would call like a retail transaction, where the ultimate buyer is going to live in that house, they're probably going to want all kinds of inspections and everything. And if there's a concern, how the heating and air conditioning is going to do, is the plumbing okay, is the electrical okay? It may be advisable, it's certainly, you're the professional here, but it may be advisable to look for an investor who isn't worried about inspections.
Well, I'm glad you brought that up, because, I do go and I do come across that quite a bit. We help folks out that are in this situation, right? But it's actually obviously after the estate planning and all that's done and the person has passed. And there is a misconception, I think, in our business that, you sell to through a traditional brokerage, you're going to have to pay all these fees, you got to have it marketable, you got to have it. And at the end of the day, what I tell them is, look, you're free to, clearly go with whichever direction you feel is the easiest, for you. And if it means going to an investor, go to an investor. We try to educate our folks and say, hey, look, let's just give you, our opinion of what the market value is. Again, as is, where is. You don't do anything to the house. And you'd be surprised that clearly that, an investor has, one game in mind, and that is to obviously make as much money as they can. And, for us as a brokerage, we want the seller, clearly the executor, to make as much as they can. So that can, really depend and fluctuates on the circumstance and how quick they want to sell this asset. But some of the concerns that maybe your clients, let's talk about that. Hypothetically speaking, on one of your clients, I come in, my wife and I, to interview you, and one of the concerns that I'm sure that I know it's on my mind. I mean, if I'm concerned about my beneficiary's ability to handle inherited money, or what if I'm concerned that they'll waste the money or lose it in a lawsuit or divorce? How do you get around something like that?
Well, so we have the ability as estate planners, depending, and we haven't talked about trusts at all, but we will, whether we're building an estate plan based on a will that most people are familiar with, or a trust, which we'll probably talk more about. In either of those ways, we're going to name beneficiaries. Who is going to receive the property when the maker of the will or the maker of the trust has died? So if you're dealing with a married couple, most typically, there's going to be some consideration for the spouse if the spouse survives they both have their own will. So if I write my will and I say, well, if my spouse survives me, then I want this to happen. If my spouse doesn't survive me, then I want that to happen. There's always a consideration for the spouse. How much and to what extent the spouse is going to be a beneficiary is always dependent upon a number of different factors. But let's just say that in your scenario, you want to make sure that if the ultimate distribution is going to go to kids, which it normally is if we're dealing with a client that has children, most of the time at some point, estate property is going to wind up going to the children. If it is one of those circumstances where you have a concern about a beneficiary, perhaps they have shown a track record of not handling money very effectively, maybe they have a substance abuse problem, maybe they have a health problem, that means they have to rely on government benefits to support themselves. All of those are very unique issues that have to be dealt with very carefully by an experienced estate planner. The way that we can do it, just to kind of foreshadow that, is if the beneficiary, let's say, is just irresponsible with money, we can have it set up so that the money that they would get is held in a trust for an extended period of time, maybe even the entire lifetime of the beneficiary, with an independent person who will make decisions, discretionary decisions, on making distributions to that beneficiary, so that it's not a situation where this entire pot of money, however large the pot might be, is just going to be handed to the beneficiary and then they'll say good luck. It won't be like that. It will be, they get a little bit at a time, almost like an allowance. And they can ask for more if they need it. Let's say they want to buy a home or start a business. If the trustee thinks it's a responsible use of the money, then they have the discretion to use the money that way.
Can you serve as a trustee yourself then for folks in that capacity? Or I would imagine it's kind of it could be an accounting nightmare.
Well, you mean if the beneficiary is going to be the trustee?
Well, if they don't want to be the trustee, if they want to appoint, through elder law planning and so forth, can they appoint, an attorney to do that for them?
They can. There are some attorneys that will do that. In my practice, we kind of try to point out alternatives. There are many other opportunities. There are trust companies, for example. Okay. Trust companies, that's what they do, is they serve as a professional trustee. And trust companies are great, generally speaking. The thing that people get concerned about is the fee. There are fees involved, obviously. And also, a trust company or any professional trustee, whether it's an attorney or a trust company, they don't know the family. They don't know the beneficiary. They don't have those intangibles to really understand. They are going to follow the law and they're going to follow what the trust says. But they're sort of missing that intangible. So sometimes what people will do is name a professional and also name a co-trustee that's a family member. So that way the family member has the ability to shed light on the intangibles. They know the beneficiary.
Makes sense.
And the professional has the ability to maintain proper accountings, follow the law, follow the trust agreement. When you have non-professional trustees that are managing long-term trusts, sometimes they can be problematic because they don't know they had to file a tax return. They don't know, they didn't bother to look at what the trust said. They just sort of guess. Those can be very problematic. So pairing the two is a good idea, I think. Ideally, certainly does still incur trustee fees. So for a very modest sized estate, maybe the opportunity to have a professional trustee just isn't there. You have to rely on a family member. Now, what you do want is you do want the family member to get professional advice.
Sure.
So we serve in that role frequently, where an executor or a trustee would come to us, and we're not going to become the executor or the trustee. We're going to counsel and advise the trustee or the executor through the process to make sure they're following the law, they're following what, the trust agreement, for example. If there's a tax return that needs to be filed, they're doing it. We want to keep them out of trouble and make sure that they're complying with what their fiduciary responsibilities are, and that's really the key.
Interesting. So how often should these be updated then with you? How often do you advise your clients that once you, let's just say you write up a trust for them and you have everything sorted out, when should they come back and see you again? And I guess life-changing events, would that be one?
Yeah, life-changing events, certainly a marriage, divorce, death, disability, anything that, or a change in relationship, for example. We have clients that have adult children that they have a great relationship with. When we create their plan, fast forward 5-10 years down the road, the dynamics have changed. And when those things happen, sometimes it causes people to reconsider their plan. That obviously is a time that you want to go back whenever one of those key events happens. But even if there's no key event or a life change, every 3 to 5 years is a good time to at least look at your estate planning documents and just read through them. Make sure that the people that you chose to make your important healthcare decisions are still in your life. They're still alive, able to do it, and that you wouldn't pick someone else if you had it to do over again. Same is true for who you would pick as an executor under your will. The beneficiaries under your will, is that still who you want to be your beneficiaries, and still in the same way? So we were talking a few minutes ago about what to do with a beneficiary that maybe has a spending problem, and for that reason maybe you decided to make their share not distributed outright to them, but rather to be distributed over time by an independent trustee. Well, if maybe that's the way you originally created your plan, but then 5 or 10 years down the road, they've matured and they have a track record of being responsible, so you no longer want it to do it that way. You just come back and we can amend the trust or the will to make sure that it comports with your new reality, and that's what we recommend.
I can imagine that puts you in kind of a bunch of different roles, as like, with all the family dynamics that are involved in this, right? Like, again, are you getting those, protecting client anonymity here? I mean, are you getting calls every now and again to try to, like, Jason, you can't do this for, these reasons, or is it just, are you trying to, how do you kind of get around all that?
You mean like the family dynamics, or you mean like when someone who is a family member of our client calls?
Well, like if somebody within, that you had, a will set up for a trust, and then all of a sudden there's a fallout, right, between the family and this particular, one of their children or what have you, and they call you back and say, hey, we need to make some changes here. Yeah. I mean, how does that work in terms of, obviously, do they need to sign anything over? Okay.
Yeah, we basically need to just update, create an amendment. If it's a trust, we will do what's called a restatement of the trust, and we'll just change the terms to whatever the client wants. One of the things that I make a practice, it's not a legal requirement, but I make a practice of whenever a client wants to disinherit a beneficiary, or if there's a vastly unequal distribution. So let's say they have 3 children and they want one of their children to get 5% of the estate and then the other 2 children to split the rest. That's a significant difference. Sure. And so what we want them to do, what I ask them to do, is to just write a letter. Right? It's not going to go anywhere. It goes in their file and that's it. The reason I do that is I want to get in their own handwriting, their own explanation for why they're doing that. We want to protect them against down the road, 20, 30 years from now maybe. Sure. When they've passed away, their estate is being administered, and that child that was disinherited or almost disinherited could mount a challenge and say, that my parent didn't intend to do that, or they were under the undue influence of one of my other siblings, or maybe they didn't even have the legal capacity at the time to make it. These are all reasons why an estate plan could be undone later on. So by having them write the letter, what we're trying to do is, A, show that they do have the requisite mental capacity to make a will at that time or to make a trust at that time. We also want to show that it wasn't a mistake. They didn't just overlook that child, or they weren't good at math, so they didn't realize that they were giving them much less. This just shows all those things. This person did have the legal capacity, it was intentional, and they did have a reason. There's no legal requirement that you have a reason, but oftentimes one of the challenges can include there's really no reason to do this. We want to show that, yes, actually there was a reason, and this is what it was. So that's just a practice we do to just try to protect the integrity of the plan.
Makes sense. I mean, and again, folks, we're talking about, people you know and trust, and who, again, this is why we would consider somebody like Jason to review these things for you, because, I mean, you're dealing with somebody's livelihood and money, and all the things that they've worked for all their years. And I know the dynamics, obviously, with money is a sticky point for some people, right? So, you even have probably considerations where I can imagine divorces and people coming into you to have their trust revised, and they may not like stepkids. You know what I mean? They may want to cut out certain things. So I'm sure that all that kind of comes into play. One of the other things is obviously as we age. Another question I had for you, and was really what happens like if you're concerned about losing your house or something like that, if you have to, get into like long-term care facilities or anything like that, what is there? I'm sure there's protections possibly that you could take.
It's a common question we get, especially when we're dealing with our retiree population. It's something that they're thinking about, reading about, researching, and they often come in with that concern is they normally pose it this way. They'll say, what can I do to protect my house from going to the nursing home? They say it exactly that way, right? Because it's a little bit of an urban legend that the nursing home actually takes your house. It really doesn't work that way. What they mean to say is that what happens if at some point in life my health status leads me to a place where the best place for me to receive care and the best place for me to be is a nursing and rehab center. And that does happen. I mean, I think most of our clients say that they're never going to do that that's never where they're going to go. I understand the intention, but the reality is that some percentage of the population, that's just what's going to happen. And so what they're trying to do is they're trying to protect their wealth so that ultimately they can make it to their kids. The reason they're doing that is that when you go into a long-term care facility like that, there's 3 ways you can pay for it. You either can have long-term care insurance, which very few people have. It is not the same as health insurance. It is not part of Medicare. It is something you have to very intentionally go buy, long-term care insurance. It's expensive, and so a lot of people just don't get it. And then when you get to a place in life where you have some medical diagnoses, you may not be able to get it at that point. You won't get through underwriting. So it's something you have to think of when you're still relatively young and healthy, or otherwise you won't get it.
And there's also age limitations to that too, right?
Well, I don't know that there are strict age limitations, but because there are strict health limitations, when you get into a certain age where you start having high blood pressure and maybe type 2 diabetes, or you've had, some diagnosis of something, maybe very early dementia, you're probably not going to get it anymore after that. So it's something you do have to kind of plan ahead. People don't plan ahead mostly for financial reasons. It's just it's an added expense, and it can be a significant expense. So for that reason, most people don't have long-term care insurance. The second way to pay for it is by just writing a check every month. I practice in Annapolis, Maryland. The going rate for a long-term care facility is $14,000 a month. So for most middle-class people, that's only going to last so long, and then you're not going to have any money. And so that's what people are talking about I lost my house to the nursing home because you had to sell the house, spend it all down before you could ultimately get to Medicaid, which is the third way that people pay for long-term care. And Medicaid is not the same as Medicare. Medicaid is its own program. It's really designed for people who just don't have the resources to pay for care, whether that's hospital care, physicians, or in the case of our retiree population, it's more often than not, it's long-term care. And so the financial requirements to be eligible for long-term care are very strict, and you can't have a whole lot of money. It's very low. It is a state-specific thing, but this is pretty consistent across the board. In Maryland, as an unmarried person, you can only have $2,500 to your name to be eligible for Medicaid. So that means that spend down happens. They have to sell the house, and they spend that money. And I say house because that's, as you know, Mike, that's where people tend to build their wealth. They're building equity over the years. That's where their wealth is for many people. It's there in their retirement accounts. So oftentimes people will go into the nursing home, sell their house. The house is gone. It's not in the family, and the equity is now gone because it has to be spent on long-term care. So we do have the ability to protect that by creating a special kind of trust. We call it a Medicaid Asset Protection Trust. We can protect the house. We can protect the brokerage account, the bank account, personal property. By putting it in that trust, it works very effectively, but the key is it has to be done well in advance. So the Medicaid rules have what's called a 5-year look back. So that means that if I go to apply for Medicaid for long-term care today, they're going to look at all of my financial records for the last 5 years. And it's right that they do that. They want to prevent abuse. And so they want to make sure I haven't given all my wealth away to my kids just like last year in order to be able to get Medicaid. So they're going to look back 5 years. So what that means is that when we create these types of trusts, we want to do it well before 5 years until there'll be a need. And so what that means for clients is they have to transition to that sort of a thing way before they think they need it. It's very similar to the need to get long-term care insurance way before you think you need it, because in order for it to work, you really have to plan ahead.
You know, that's a lot of things you really need to think about with all of, you know, estate planning. And I guess what would be your advice for, you know, maybe a potential client coming into you that just doesn't even know where to start with all this? I mean, you know, maybe they don't even have a will. It's just, you know, and they just, or it could be taboo. Like, how do they even have that? I mean, some spouses don't even like to converse about this stuff. Like, so how do you, I guess that's where your therapist role comes out, right?
That's what we pride ourselves in my office on trying to make it simple. If we make it complicated for clients, they're going to be overwhelmed and they're not going to want to do it. So we have a way of making it a fairly pleasant process. I mean, I know it doesn't seem like it could be. We gather information in a way that seems very, I mean, this is what our clients tell us, and it's what we're going for, is we want it to be pretty simple and straightforward, and then relaxed when they come into the office. We are not a buttoned up, formal, we're not going to put the bright lights on them. We're just going to have a regular conversation just like you and I are having. Yeah. And we talk about the options. So we just talked about how to protect assets if they need long-term care. We'll explain exactly how that works. For people who are worried about probate, which is a very common concern, they want to avoid probate if possible so that it'll be easy for their kids, easy for their spouse. We just explain in a very common, using normal words that people use, not fancy legal words, to explain how we can, what the solution is. How can we help you avoid probate? And we walk them through it, and we talk about their situation. If they have one of their kids has a spending problem or has a substance problem, we explain how, just like you and I did. And then we try to make it easy and straightforward. And then we have a prescribed process. We meet several times, spaced a few weeks to a month apart, to make sure that we're dotting all the I's and crossing all the T's, so that ultimately, when they get their estate plan, it wasn't the product of a late night in front of a computer just making guesses about what's good. It's a product of very thoughtful conversation, information gathering, advice, guidance, and then ultimately you get a product that you really know is going to work. It's going to meet what your needs are. And then in the future, if something changes, you know who to go back to. You know, you know who your trusted professional is, and you go back. And I think that's really the way to do it, and people feel a lot more confident. The thing about estate planning, unlike, you know, if you hire an attorney to represent you in a car accident or in a divorce or something like that, you're going to find out right away how good they are. With estate planning, you're really not going to know, you know, because the product of it most likely isn't going to be revealed or have real significance until after our lifetime. So it's something where you really have to have confidence that who you're dealing with has your best interest in mind, is competent, and makes you feel comfortable to work with.
Very trustworthy position that, you know, you obviously had as their fiduciary, right? So you're looking at, you know, at the end of, I would say you do seminars, right, to educate folks on how is it that you bring them in to talk to you about this? Is it just you send you do a little bit of social media yourself?
We do it a variety of different ways. It depends on sometimes groups, churches, and other organizations will invite us to come in and give a presentation to the people that they invite, and we love doing those. We also do some ourselves, and we promote them. You know, sometimes on social media, sometimes we mail out invitations. It doesn't matter. The idea is we want to get as many people there as possible, because this is one area where it's like you don't know what you don't know, and in order to find out, you kind of have to be a little proactive on yourself to go learn more. If you don't do that, you're just not going to know. And I get people tell me all the time when they come to these seminars that we put on, they're like, you know, I didn't know anything about this stuff. Obviously, everyone knows what a will is, but you don't really know the intricacies of it, or what the concerns or challenges, what the opportunities are. People don't know you have the opportunity to avoid probate. You don't know they have the opportunity to protect their assets from long-term care costs. They go to something like one of our seminars, and we do online stuff too, webinars. That's where they hear about this stuff, and they're like, first of all, I didn't know that was a problem, and I didn't know there was a solution. Or I did know it was a problem because I dealt with my parents' estate, but no one ever told me there was some way to avoid some of these complications. And so it's educational, and I just can't even tell you how many people come in and they're like, I never would have known about this stuff, so I'm glad I learned about it, and now I want to do something about it.
I mean, that's great, Jason. I don't recall any estate attorney going through, I feel like, I'm sure it's probably common practice, as you would know in your industry. I just haven't heard of somebody that, educates people the way that you do. And I guess for our listeners out there that, clearly can be, across the United States, clearly Jason's in the Maryland area, folks, but we do want you to reach out to Jason if you're in Maryland, or if you've a family member that Jason could help out, clearly. Jason, do you have any final key takeaways that we can kind of tell the listeners about, maybe even if they are out of state? What should they be looking for, and what should they be interviewing their potential estate planning attorney?
I think the biggest thing, Mike, is that you don't want to. First of all, no matter what state you're in, don't go online to have your estate plan prepared. Okay, all right. 70% of adults do not have any estate plan in place. 70%. And that means no will, no powers of attorney, no trust, nothing. And that is a reflection, I think, on just people not being educated about it and not knowing what's available, not knowing where to go. And so your question is, where do you go? And my answer to that is, you really want to go to an attorney or a law firm that focuses their practice in this area. I get a fair amount of clients that come in and they've had a will prepared in the past, and they like the attorney fine. I mean, they had no problem with the attorney. They felt comfortable with them. And I even could look at their will, and in most cases, it's fine for what they wanted. It's perfectly fine. But when we start talking about some of the other planning opportunities, things like how to avoid probate or protect your assets or whatever, they'll say the attorney never brought any of that stuff up. And the reason, it's an innocent reason. It's the attorney is doing car accidents and divorces, and then someone wants a will and they draft a will. They know how to do it. But they don't know the intricacies of how to avoid probate. They don't know the intricacies of how to protect your assets, and any of the myriad other concerns that can come up. So my advice would be this, and this is really true of any law practice: find an attorney that focuses their practice on the problem that you have. You would do it with a doctor. If you have a heart problem, you're going to go see a cardiologist. If you have a skin problem, you're going to see a dermatologist. If you need surgery, you're going to go to a surgeon. Too many people don't do it, don't address it that way with attorneys, and I think it's important. The legal field is extremely complex. Even in one little narrow field like the one I practice, I have to take lots of continuing ed. I have to read and study. I had to really get a good understanding of things. So I know that no attorney who has a very broad general practice is able to dive in that level of detail. So you're doing yourself a favor by finding a professional that really focuses on what exactly you need. So there are estate planning and elder law attorneys all across the country that I would do the research to find a good one where you are. Maybe get a referral even from your general practice lawyer you have a relationship with. Say, look, I've got some estate planning concerns, or I've got a concern about long-term care, Medicaid, asset protection. They should be able to plug you in with some other attorney who focuses their practice there. People call me and say, I was involved in a car accident. What do I do? Well, I can't really help you because that's not my practice. Gotcha. But I do know personal injury lawyers, and I'd be happy to refer you to a good one. So that works.
That makes great sense. Jason, wow, you gave us a lot of information, a lot of things to think about. I know, we could have another segment on you coming back and just talking about business planning. I think about that now for my own company and our own business, and really appreciate the opportunity for you to come out here and talk to our viewers about, estate planning. It's something that's as important as it is, these assets in your life. Really, you folks need to reach out to a good estate planner like Jason. Jason, do you want to, give us a phone number or a way to reach you? We'll plug it in the show notes. And
yeah, sure. Our office number is 410-570-1671. Well, I should say it again, 410-570-1671. And our website is jcjohnsonlaw.com. And lots of information on the website too. Just general scenarios, like if this happens, this is a good idea. It kind of discusses, we have blog entries and things like that.
Wow, fantastic. Jason, thanks again. Really appreciate the opportunity.
Thank you for having me, Mike.
Thank you folks for checking us out, and we'll look for you next time. Thanks so much.